Marginal note: export from provinces of resources. 2. In each province, the legislature may make laws in relation to the export from the province to another part of Canada of the primary production from non-renewable natural resources and forestry resources in the province, and the production from facilities in the province for the generation of electrical energy. But such laws may not authorize or provide for discrimination in prices or in supplies exported to another part of Canada. Marginal note: authority of Parliament. 3. Nothing in subsection 2 derogates from the authority of Parliament to enact laws in relation to the matters referred to in that subsection, and, where such a law of Parliament and a law of a province conflict, the law of Parliament prevails to the extent of the conflict. Marginal note: taxation of resources. 4. In each province, the legislature may make laws in relation to the raising of money by any mode or system of taxation in respect of a. non-renewable natural resources and forestry resources in the province, and the primary production therefrom, and b. sites and facilities in the province for the generation of electrical energy, and the production therefrom, whether or not such production is exported in whole or in part from the province, but such laws may not authorize or provide for taxation that differentiates between production exported to another part of Canada and production not exported from the province. Primary production. 5. The expression primary production has the meaning assigned by the 6th Schedule. Marginal note: existing powers or rights. 6. Nothing in subsections 1 to 5 derogates from any powers or rights that a legislature or government of a province had immediately before the coming into force of this section. And note 49. Education. Marginal note: legislation respecting education. 93. In and for each province, the legislature may exclusively make laws in relation to education, subject and according to the following provisions. 1. Nothing in any such law shall prejudicially affect any right or privilege with respect to denominational schools which any class of persons have by law in the province at the Union. 2. All the powers, privileges, and duties at the Union by law conferred and imposed in Upper Canada on the separate schools and school trustees of the Queen's Roman Catholic subjects shall be, and the same are hereby extended to the dissentient schools of the Queen's Protestant and Roman Catholic subjects in Quebec. 3. Where in any province a system of separate or dissentient schools exists by law at the Union, or is thereafter established by the legislature of the province, an appeal shall lie to the Governor-General in Council from any act or decision of any provincial authority affecting any right or privilege of the Protestant or Roman Catholic minority of the Queen's subjects in relation to education. 4. In case any such provincial law, as from time to time seems to the Governor-General in Council requisite for the due execution of the provisions of this section is not made, or in case any decision of the Governor-General in Council on any appeal under this section is not duly executed by the proper provincial authority in that behalf, then, and in every such case, and as far only as the circumstances of each case require, the Parliament of Canada may make remedial laws for the due execution of the provisions of this section and of any decision of the Governor-General in Council under this section. And note 50. Marginal note: Quebec. 93. A. Paragraphs 1 to 4 of Section 93 do not apply to Quebec. And note 51. Uniformity of laws in Ontario, Nova Scotia, and New Brunswick. Marginal note: legislation for uniformity of laws in 3 provinces. 94. Notwithstanding anything in this Act, the Parliament of Canada may make provision for the uniformity of all or any of the laws relative to property and civil rights in Ontario, Nova Scotia, and New Brunswick, and of the procedure of all or any of the courts in those 3 provinces, and from and after the passing of any Act in that behalf. The power of the Parliament of Canada to make laws in relation to any matter comprised in any such Act shall, notwithstanding anything in this Act, be unrestricted. But any act of the Parliament of Canada making provision for such uniformity shall not have effect in any province unless and until it is adopted and enacted as law by the legislature thereof. Old age pensions. Marginal note: legislation respecting old age pensions and supplementary benefits. 94. A. The Parliament of Canada may make laws in relation to old age pensions and supplementary benefits, including survivors and disability benefits irrespective of age, but no such law shall affect the operation of any law present or future of a provincial legislature in relation to any such matter. And note 52. Agriculture and immigration. Marginal note, concurrent powers of legislation respecting agriculture, etc. 95. In each province the legislature may make laws in relation to agriculture, in the province, and to immigration, into the province, and it is hereby declared that the Parliament of Canada may from time to time make laws in relation to agriculture, in all or any of the provinces, and to immigration, into all or any of the provinces. And any law of the legislature of a province relative to agriculture or to immigration shall have effect in and for the province as long and as far only as it is not repugnant to any act of the Parliament of Canada. 7. Judicature. Marginal note, appointment of judges. 96. The Governor-General shall appoint the judges of the Superior, District, and County Courts in each province, except those of the Courts of Probate in Nova Scotia and New Brunswick. Marginal note, selection of judges in Ontario, etc. 97. Until the laws relative to property and civil rights in Ontario, Nova Scotia, and New Brunswick, and the procedure of the courts in those provinces are made uniform, the judges of the courts of those provinces appointed by the Governor-General shall be selected from the respective bars of those provinces. Marginal note, selection of judges in Quebec. 98. The judges of the courts of Quebec shall be selected from the bar of that province. Marginal note, tenure of office of judges. 99. 1. Subject to subsection 2 of this section, the judges of the superior courts shall hold office during good behavior, but shall be removable by the Governor-General on address of the Senate and House of Commons. Marginal note, termination at age 75. 2. A judge of a superior court, whether appointed before or after the coming into force of this section, shall cease to hold office upon attaining the age of 75 years, or upon the coming into force of this section, if at that time he has already attained that age. And note 53. Marginal note, salaries, etc., of judges. 100. The salaries, allowances, and pensions of the judges of the superior, district, and county courts, except the courts of probate in Nova Scotia and New Brunswick, and of the admiralty courts in cases where the judges thereof are for the time being paid by salary, shall be fixed and provided by the Parliament of Canada. And note 54. Marginal note, General Court of Appeal, etc. 101. The Parliament of Canada may, notwithstanding anything in this Act, from time to time provide for the constitution, maintenance, and organization of a General Court of Appeal for Canada, and for the establishment of any additional courts for the better administration of the laws of Canada. And note 55. 8. Revenues, debts, assets, taxation. Marginal note, creation of Consolidated Revenue Fund. 102. All duties and revenues over which the respective legislatures of Canada, Nova Scotia, and New Brunswick, before and at the Union had, and have power of appropriation, except such portions thereof as are by this Act reserved to the respective legislatures of the provinces, or are raised by them in accordance with the special powers conferred on them by this Act, shall form one Consolidated Revenue Fund, to be appropriated for the public service of Canada, in the manner and subject to the charges in this Act provided. Marginal note, expenses of collection, etc. 103. The Consolidated Revenue Fund of Canada shall be permanently charged with the costs, charges, and expenses incident to the collection, management, and receipt thereof, and the same shall form the first charge thereon, subject to be reviewed and audited in such manner as shall be ordered by the Governor-General in Council, until the Parliament otherwise provides. Marginal note, interest of provincial public debts. 104. The annual interest of the public debts of the several provinces of Canada, Nova Scotia, and New Brunswick, at the Union shall form the second charge on the Consolidated Revenue Fund of Canada. Marginal note, salary of Governor-General. 105. Unless altered by the Parliament of Canada, the salary of the Governor-General shall be £10,000 sterling money of the United Kingdom of Great Britain and Ireland, payable out of the Consolidated Revenue Fund of Canada, and the same shall form the third charge thereon. And note 56. Marginal note, appropriation from time to time. 106. Subject to the several payments by this Act charged on the Consolidated Revenue Fund of Canada, the same shall be appropriated by the Parliament of Canada for the public service